The insurance company called on a Thursday morning. The woman was professional and efficient, and she said, "Ms. Simmons, we are calling regarding a claim filed under policy number 4471-886. As the primary policyholder, you are required to authorize continued inpatient coverage for the secondary holder. The authorization window is 48 hours. I said, "I'm sorry, which policy is this?" She gave me the number again. I recognized it. It was the policy I had been on for 11 years of marriage. The policy I had meant to remove myself from after the divorce. The policy I had put on my to-do list 18 months ago and had not gotten back to because the divorce had consumed every available hour, and when it was finally done, I had been so tired of administrative tasks that the insurance update had simply sat there, undone, while I rebuilt my life. I said, "Who is the secondary holder?" She said, "The claim was filed by Daniel Simmons. He was admitted Tuesday evening. Emergency cardiac event. Daniel, my ex-husband. In a hospital 2 miles from the house we had shared for 9 years." I said, "What exactly does my authorization cover?" She said, "As primary policyholder, you are the account decision maker. Continued inpatient coverage beyond 72 hours requires your explicit authorization. Without it, the claim defaults to the secondary holder's individual plan, if one exists." I said, "Does one exist?" A pause. She said, "We show no secondary individual policy on file for Mr. Simmons." I sat with that for a moment. My ex-husband was in the hospital with a cardiac event. He had no individual insurance. He was covered under a policy I had forgotten to update, and I had 48 hours to decide whether to authorize his continued coverage. I said, "I need to call you back." I hung up. I opened my laptop, not to authorize, not to deny, to find out everything I did not yet know. My name is Carol Simmons. I am 44 years old. I was married to Daniel Simmons for 11 years. We met at a conference in Atlanta when I was 29 and he was 32, and we were both in pharmaceutical sales, and we had enough in common to build a life, and not quite enough to sustain it. The divorce was finalized 18 months ago. Not dramatic. We had simply arrived at the conclusion that we were better apart than together, and had spent 2 years getting there and 1 year making it legal. Daniel and I had no children. We had a house, 2 cars, shared finances, and an insurance policy that had been under my name because my employer's plan had always been superior to his, and because maintaining separate policies had seemed wasteful when we were building something together. When we stopped building together, I had meant to separate everything. I had separated most things. Not everything. The 48 hours began at 9:17 on a Thursday morning. I spent the first 3 hours of them researching. The first call was to my attorney. Her name is Michelle, and she handled the divorce, and she knows the full history of our financial separation. I had her on the phone within 20 minutes of hanging up with the insurance company. I said, "Michelle, I need to understand something quickly. Daniel is in the hospital. I am apparently still the primary policyholder on his insurance. What is my legal exposure if I authorize coverage versus if I do not?" Michelle said, "Authorize or decline are both legitimate choices as primary policyholder. Neither creates liability for you. What I need to know is whether the divorce decree included any provisions about insurance continuation." I said, "Pull the decree. I don't remember the specific language." She called me back in 40 minutes. Michelle said, "Carol, the decree has a provision, Section 14. Each party was required to maintain or obtain individual health coverage within 60 days of finalization. Daniel was required to establish his own policy." I said, "Did he?" She said, "That is what I am about to find out." She called the insurance company directly. She called me back in 20 minutes. Michelle said, "Daniel did not establish individual coverage. He is in violation of the decree. He has been uninsured for 18 months, relying on a policy he was legally required to exit." I sat with that. Daniel had known. He had known he was required to get his own coverage. He had not done it. He had remained on my policy, the policy under my employer, under my name, under my account, for 18 months after the divorce without telling me and without establishing the coverage he was legally required to have. I said, "Michelle, what do I do with this?" She said, "That is entirely your decision. Legally, you have two options. You authorize continued coverage and you handle the decree violation separately. Or you decline to authorize and Daniel's coverage lapses, at which point the hospital billing becomes his problem to resolve." I said, "If I decline, what happens to him medically?" Michelle said, "The hospital is required to provide emergency stabilization regardless of insurance status. He would not be turned away. He would, however, face significant out-of-pocket costs." I said, "How significant?" She said, "Cardiac inpatient care, 3 or 4 days minimum, possibly more, tens of thousands of dollars at minimum." I said, "I need 24 hours. Michelle said, "You have 48. Use them." If you have ever been handed a decision that was not yours to make but was yours to carry, you already know why this story exists. Subscribe and hit the bell. I'll be here every week. The second call I made that morning was to my accountant. Not about the insurance, about the house. There was something Michelle had said in passing during the divorce proceedings that had never been fully resolved. A question about the deed to our house that had been deferred pending other negotiations, and that had ultimately been resolved, I had believed, in a way that was clean and documented. I had believed this. I called my accountant because something about the insurance situation had activated a specific professional instinct. The instinct that said, when one administrative detail has been mishandled, check the others. My accountant, a careful man named Frank, accessed the Fulton County property records while I was on the phone. He was quiet for a moment. Frank said, "Carol, the deed on the house was modified 9 months ago." I said, "Modified how?" Frank said, "A quit-claim deed was filed in August. It transferred your remaining interest in the property to Daniel." I stopped typing. I said, "I signed a quit-claim deed?" Frank said, "The deed on file shows your signature." I said, "Frank, I did not sign a quit-claim deed. We sold the house as part of the settlement. Both parties signed the sale documents. The proceeds were split. The house is gone." Frank said, "The house on Magnolia was sold, yes. This is a second property, a rental property on DeKalb Avenue that was listed in the divorce assets as jointly owned." The rental property. A small house we had purchased together in 2018 as an investment. It had been in the asset list during the divorce. The settlement had specified that it would be sold and the proceeds split equally. The sale had not yet happened when the divorce was finalized. It had been in progress, with a real estate agent engaged. Frank said, "The sale never completed. Instead, a quit-claim deed was filed, transferring your interest to Daniel." I said, "When was this filed?" Frank said, "August 14th, 8 months ago." I said, "What is that property currently worth?" He checked the recent comparables. Frank said, "Approximately $280,000. I looked at the wall. My ex-husband was in a hospital 2 miles away with a cardiac event. He had been on my insurance policy for 18 months in violation of a divorce decree. He had filed a quit-claim deed transferring my share of a $280,000 property to himself 8 months ago using what appeared to be my signature. I said, "Frank, I need to know if that signature is mine." Frank said, "You'll need a forensic document examiner for that. But Carol, you can challenge a quit-claim deed that was filed fraudulently. The statute of limitations in Georgia for fraud is 4 years. I said, "Get me the name of the best examiner you know." Then I called Michelle back. The forensic examiner's name was Dr. Patricia Walsh. She worked out of a firm in Buckhead that handled document authentication for legal proceedings throughout the Southeast. Michelle had used her twice in property disputes and described her as meticulous and fast. I emailed her the scanned deed at 11 that morning. She called me at 4 in the afternoon. Dr. Walsh said, "Ms. Simmons, I have completed a preliminary analysis of the signature on the quit-claim deed you submitted." I said, "What did you find?" She said, "The signature is inconsistent with the reference signatures you provided from your driver's license, your divorce decree, and your tax filings. There are specific letter form inconsistencies in the capital C and the terminal stroke of the S that are present consistently across your authentic signatures and absent from the deed signature. In my professional opinion, this signature was not produced by you." I sat very still. Dr. Walsh said, "I can provide a full written report within 72 hours. I said, "Please do." I called Michelle immediately. Michelle said, "Carol, this changes everything. We are no longer looking at an insurance authorization question. We are looking at potential deed fraud. Criminal exposure for Daniel." I said, "I understand that." Michelle said, "The insurance authorization, do you want to discuss what to do with it now?" I thought about it. Daniel was in a hospital 2 miles away. He had a cardiac event. He had no individual insurance. He had been on my policy in violation of the decree for 18 months. He had filed a fraudulent quitclaim deed on a property worth $280,000 to steal my share. And I had 7 hours left on my authorization window. I said, "Michelle, here is what I want to do. I authorize the coverage. I want to explain this because I think it is the part people find most surprising and because the explanation matters. I authorized it not because I forgave Daniel, not because the deed situation was uncertain. Dr. Walsh's report would make it very certain very quickly. Not because I thought Daniel deserved my protection. I authorized it because I was not willing to be the person who made a medical decision for someone based on what they had done to me financially. Those are two separate things, and I would not mix them. A person's health is not a bargaining chip. Not even when that person had spent 18 months on your insurance without authorization and had apparently signed your name to a deed that transferred $140,000 of your equity to himself. That accounting would happen through the legal system, through Michelle and Dr. Walsh and the Fulton County courts, through a process designed specifically for this kind of harm, not through a 48-hour insurance window. I called the insurance company at 4:47 in the afternoon, 3 hours before the window closed, and I authorized continued coverage. Then I asked the representative one additional question. I said, "Can you tell me the total value of claims filed under this policy in the past 18 months by the secondary holder?" She said, "I can provide that information to the primary policyholder. One moment." She came back with a number. 18 months, 7 claims, total value $23,400. $23,400 in claims filed by a man who was legally required to have his own insurance and who had been using mine without my knowledge for a year and a half. I wrote the number down. Michelle would need it. If this moment stayed with you, leave me a comment. Has someone ever used something that was still technically yours because you had not yet taken it back? Tell me what you did when you found out. I read every single one. Dr. Walsh's full report arrived 71 hours after my initial inquiry. 14 pages, detailed methodology, side-by-side analysis of the letter forms, conclusory language that left no reasonable alternative interpretation. The signature on the quitclaim deed was not mine. Michelle filed in Fulton County Superior Court 10 days after the report arrived. The complaint alleged deed fraud, violation of the divorce decree insurance provision, and unjust enrichment through unauthorized use of my insurance policy. Daniel retained an attorney. His attorney contacted Michelle 2 weeks after the filing. Daniel's attorney said, "My client acknowledges certain irregularities in the post-divorce administrative process and is prepared to discuss a resolution." Certain irregularities. The phrase of someone who has done something specific and is hoping to resolve it with language that doesn't name what it was. Michelle said, "Your client filed a fraudulent deed and has been using my client's insurance in violation of a court order for 18 months. Those are not irregularities. Those are specific actionable harms with specific dollar values. We are prepared to discuss resolution when your client is prepared to be specific." The negotiation took 6 weeks. The resolution, the quitclaim deed was voided, and the DeKalb Avenue property was sold as originally ordered. My share of the proceeds, $138,000, was deposited into my account. Daniel reimbursed the $23,400 in insurance claims he had filed on my policy. The decree violation was formally documented. He was not criminally charged. This was my decision. Michelle had presented the option clearly, and I had considered it carefully, and I had decided that the financial resolution was what I needed, and that a criminal process would cost me years of my life that I preferred to spend on other things. Some people will disagree with that decision. I understand why. It was mine to make. I removed Daniel from my insurance policy on the day the settlement was signed. The update that had been on my to-do list for 18 months took 11 minutes. 11 minutes. 18 months of exposure, 11 minutes to close. I am 44 years old, and my ex-husband spent 18 months on my insurance policy, filed a fraudulent deed, and was in the hospital when I found out about both. The first thing: administrative tasks after a major life transition matter. The divorce consumed every available hour for 2 years, and when it was finally done, I was exhausted. The insurance update went on the to-do list and stayed there. This is understandable and human and also costly. When a major life transition ends, a divorce, a death in the family, a business dissolution, there is a category of administrative tasks that feel less urgent than the emotional work and that get deferred while the emotional work happens. These tasks are not actually less urgent. They are the infrastructure of the new life you are building, and they contain exposure points that do not announce themselves until someone else exploits them. Make the list. Work through it. The insurance update takes 11 minutes. The D-check takes a phone call. The financial account audit takes an hour. These things do not feel important until they are. The second thing is about the decision I made in the 48-hour window. I authorized Daniel's coverage. I did this while knowing he had violated the decree and while suspecting, correctly, that the deed situation was not what it should be. I authorized it because I separated the medical question from the financial question and because I believed they were separable. Not everyone will make this choice, and not every situation makes it the right one. What I want to say is that I made it deliberately, from a position of full information about what Daniel had done, and that I do not regret it. The financial harm was addressed through the legal system. The medical situation was addressed on its own terms. Those two things can coexist. The third thing is the most practical, and I want to say it plainly. Check your property records. Not occasionally, annually. Go to your county's property records portal and search your name and your address and verify that what you see matches what you believe to be true. In Georgia, this takes 5 minutes on the Fulton County website. Every county has an equivalent. Property records are public. They are online. They do not require an attorney or a fee. I did not know a quitclaim deed had been filed on my property for 8 months. It had been filed 8 months before Daniel ended up in a hospital, and an insurance company called me, and I had the professional instinct to check the rest of the administrative record. If that call had not come, if Daniel had not had a cardiac event, if the insurance company had not called me, if I had not had the instinct to ask Frank to pull the property records, I would not have found the deed until the property was sold and the money was gone. Check your records. Today. Before the phone call that prompts you to. Hi everyone, thank you for being here. Tell me in the comments, have you ever found out that an administrative task you put off had been quietly creating exposure you did not know about? And which moment stayed with you longer? The insurance company's call or Frank telling you about the deed? I read every single one. If this story reached you today, subscribe. What comes next will stay with you too. Carol Simmons, Atlanta, Georgia.